or that's waived for these.
Which draft are we looking at? Can you tell me the title of the document?
It's LC 8889.
Thank you.
Dated 11/13.
Got it.
Okay. And the question that Marissa is asking relates to page 4.
Although we do have information to beneficiaries.
We do, yes, right.
Yeah, so is that what we want?
I think so.
4 months after the.
Mm-hmm.
Okay.
Anybody got any qualms about that?
Just for the blank in section 8.
Yep.
Yeah.
Well, you can't close can't close the probate while the wrongful death case is pending. That looks like you could if you're going to say 4 months.
I put a comment there saying something about after the resolution of the wrongful death claim. So that was right.
And that's exactly what I would say, you know.
I guess that's right. I mean, in the probate statute, it's 4 months, but you know that you also have to pay creditors and have marshaled assets by then. So maybe we do need language there. Maybe move to close the estate after resolution of the claim.
Well, after resolution of the wrongful death claim and distribution of all funds, because even after the wrongful death claim, we can have another year of litigation over apportionment.
Okay, good.
No earlier than 4 months.
Yes, right, no earlier than 4 months.
Or after the.
Faster. Yeah.
So, Lane, if I might, I think the language might need to be no earlier than 4 months and after resolution of the wrongful death claim and distribution of any funds received on the claim, because if you don't talk about resolution, then it leaves a question of what do we do if the wrongful death claim goes to a defense verdict. We can't close because we'll never have funds to distribute. Now we're stuck forever.
Yeah, okay. Okay.
All right. So then, okay.
Did you want me to talk about the other changes?
Yes, yeah.
So, some of these were just little word changes, like taking out decedent and putting in the attorney for the personal representative. Oh, I did something different for the amount of the prayer.
Yeah.
I didn't like that prayer language, so I did.
Yeah, we didn't
the
use
amount
prayer.
of the claim, but I don't know if that's right either. Where's that? It is on page 1, section 3, 2D.
Yeah, we disapproved of prayer.
Yeah, because you're not always going to have.
Yeah, I
think the amount of the claim is right.
I think
that's what's in the complaint.
Sure.
Yeah, claims.
And that would also be the number in the demand letter, so that works.
Right, I was going to say, because it may not be, that's one of the reasons we didn't like prayer, because there may not be a complaint.
Exactly, yeah.
Yeah, so claim is just, that's what you're asking for. And I think that's fine.
Okay, and then in G, on the next page, well, I don't know if it's on the next page on your document.
Yeah.
Two documents. So we took out stating the proposed disposition of the settlement proceeds and just last stating the amount of payments that were reimbursements owed under 30030.
Just calling out. What's in 30030, okay?
Then at the end of that section, we took out necessary and proper and put appropriate. Section 6, we put the case number instead of the clerk's file number, although there's still that other statute that uses the clerk's file number, but I mean, it's okay to update it here and not have it there.
Yeah.
Then I fixed in, later in section 6, there were a bunch of references to the final account. So then now it says the final account or the statement under section 7, which is the, what do we call that? The statement of compliance? Verified statement. Yeah. And I left the final account in there since I guess somebody might not want to waive it for reason.
Well, let's think.
Well, that was one thing that I had a question about on page 3, subsection 4. It talks about is before the filing of the final account or statement under the verified statement. Those are not expected to be filed filed for the wrongful death claim, right?
Right.
And I don't know that that's addressed.
What do you mean?
If I might, Lane?
Yeah, she's saying you wouldn't file a final accounting in a wrongful death only estate. Yeah, Brooks.
Instead, you would file the substitute that's called out in section 7(1) B.
Yes.
And that's why it's an or, not an and.
Yeah, so in the wrongful death claim, you're filing this thing under section 7, which is the, in lieu of the final account.
Right.
You're filing a statement.
Right.
So do we need, this is under the heading, probate for sole purpose of pursuing a wrongful death claim.
So you would never file a final
You would never
account.
file a
Okay,
final
that's
account,
fine.
yeah.
Yeah.
But then maybe you would substitute for that, you know, the section 7, whatever, the other requirement for closing it.
Yeah, that's what's referred to in 7.
Are you looking at the right one, Jennifer?
Are you saying that you would never have a final account?
In a wrongful death only case.
I think you would. Brooks, how do you pay your PR fee? How do you approve other administrative expenses?
Or
You
attorney.
do now, but under this you wouldn't.
No, it comes out of.
Well, Brown against Hackney allows a PR fee on the wrongful death gross proceeds. I've generally thrown that into my petition to approve settlement and pay PI counsel. And then at the end, when we're closing it up to get my administrative fees paid, I've generally been filing a petition for approval of fees. And once I get it, I file a receipt and a petition to summarily close because there's nothing left to do, which is way easier and quicker than a final account. But, you know, yes, you're right. My fees must be approved by the probate court.
But it's not a final account.
I don't go to the effort to prepare a final. Yeah.
Yeah.
So my only concern is page 3, subsection 4, in your bottom. What if I have the final account or statement under section 7?
Right.
Okay, so it's just statement.
Yes.
7.
Right.
We take out.
Final account. Yeah.
Yeah.
So, when does the beneficiary who's not received notice of the wrongful death approval petition get to object to the PR breach of fiduciary duty if there's no final account?
Fair question.
And they haven't had notice of the settlement.
Here we go again.
It's an innocent question, it's a true question.
Yep.
Well, we're certainly not defining a place where that can or / must be done. Do we need to do that? I mean, yeah, again, if you're in the position of you think it's a $10 million claim and the PR settle it for $100,000, you're going to be highly motivated to file your objection. Do we need to create a mechanism for that like we have for the final?
What are you gonna object to?
No, Brooks is asking, do we need to create?
Right.
Say that again, Brooks.
Sure. Well, and to answer I don't know who's speaking, but the question, it is a weird thing here under In re White's estate that the court approves the settlement without notice and opportunity to object to the beneficiaries. Normally, court approval is conclusive proof that the PR's conduct was correct, but here, this is the only place in probate land where that happens, where the beneficiaries haven't yet had their right. So I don't think we can cut off a beneficiary's right to object by saying, well, in secret, the judge approved it, trust me. So there has to be a time, a place for a beneficiary to prove up the fact that you settled short. All right, I agree with all that.
No, Brooks, but there were objections at our last meeting, because one way to do that would be to require the pre-settlement notice.
Well,
So
and that gets,
So the beneficiaries have the chance.
yeah,
Go ahead.
but to carry Jim Hughley's water, that's
Yeah.
hugely problematic if that's required for just mechanical, logistical reasons. But those reasons can't overwhelm the beneficiary's due process rights to vindicate their property right.
You didn't carry Jim's water that well.
Well, you know, the practical problem he came up with is, what if I'm 2 weeks out from a date certain trial? This is the best offer we're ever going to get. The defense is going to sunset it because they have to prepare for trial. You know, if we're going to require notice to beneficiaries, we need to explicitly give the probate court discretion to vastly shorten the time, to the point that maybe what happens is they get a notice from the PR that says, hi, it's Monday. On Wednesday at 1 p.m., I'm going to be in front of a probate judge to discuss this, and you better be there if you care. Because sometimes that's what we have to do, otherwise we lose the settlement.
I don't have any problem with an expedited review of it. And that can be a very small number of cases. Am I right, Brooks, or am I incorrect? It's a large number.
No, you're correct. I've had one in my career at all, and it was exactly the thing Jim Hughley feared. It was the kind of wacky, distaff, unrepresented person who just knows that a hangnail is worth $1 million. And that's the only time it's happened.
Okay, and I am fully on board with that as a matter of sound constitutional principle and fairness and good practice. Somebody tell me that we're not going to have OTLA loaded to the gills to kill this thing in a legislature that is probably going to be predisposed to be influenced by OTLA, and that we're not just... Yeah, go ahead.
Yeah, here's what I can promise in that regard. I can, and I already told you earlier that I would, once we get closer to final, and I think maybe this is the time, interface with the OTLA Legislative Committee and try to get them on board. And why don't I promise that I will, while we're in this meeting, one of the reasons I'm not there is so I can send email the committee and tell them I need a phone conference to talk about this. Okay. And if our Leg Committee is strongly against this, I'll report back to you, Lane. But if I can convince them that it's not a bad idea, which I think I can, I don't think we'll have it, I'll let you know. But I can give you that intel now, long before we're in the session and it's too late to deal with it.
Yeah. Okay, good. Yeah, we do not want to find that out on the morning of the hearing. And I hate to be just purely political about it, but because I do think in terms of principle and practice, it is best to give the advance notice, but I'm also concerned about enactability and getting this done. And if we're going to end up with that kind of opposition, I want to know ahead of time, and we will punt in the name of practicality, I guess. But if you can do it, Brooks, I'm happy. So in that case, then what's it look like? The notice that let's just talk so that you have a sense of what you would be describing. We have the court approval of settlement under Section 3. We would say that, let me see. No, this is wrongful death only. Well, let me see. Where would that go?
Are we saying
yeah, it would be Section 3. Yeah, it would be Section 3. That do you send a complete copy of the petition? These are wrongful death beneficiaries. Of course, they're defined up in Section 1. So do we send a complete copy of the petition? Do we just send a summary? What is it that we send?
I would argue, because, I would argue that we send them the same thing the judge is looking at, fair being fair. That'd be the petition and maybe the declaration, maybe. And then we need something explicit in what I'm expecting to be let me just look at it. It'll be sub 3 of Section 3, which we'd be adding. It says the court can fashion any notice and hearing period appropriate to the case, something very broad like that, to let me walk in on Monday and say, look, we need a hearing Thursday, Judge. Something like that. Because I'm a big fan of giving trial judges discretion.
Yeah. We could say 20 days or on less time.
Upon showing of good cause.
Yeah, upon showing a good cause.
Yeah, you bet.
That way, I think it's, because for one, I wouldn't leave it just to whatever the court says, because then you have to ask the court every time, and you probably don't need to do that in most cases.
Should it be 15
Good.
The probate code, should it be 15 days?
Okay, I guess, I was thinking 20 like a final account, but 15 is fine with me.
So less time.
Yeah, probably less time than easier. Okay, let's say 15 days. Copy of the petition and the statement. Is there information in the statement that should not go to the beneficiaries?
Well, and that gets back to the declaration of counsel.
Yep.
And I personally think that the beneficiary should be entitled to see that because, as we've discussed before, if it's a wrongful death case, defendants really aren't going to be able to get confidentiality in the regular course as much as they want it. And, you know, the solution to that is quit negligently killing people.
Yeah. Well, we got a law on that too. And look what good it's done. All right, you know, then I guess for the purpose of what you're going to put to the OTLA Legislative Committee, let's go for it.
I'm typing an email to that committee now, by the way.
So, Marisa, that would be a new section 3, requires notice to beneficiaries, as defined in section 1, 15 days with notice of time to eject, 15 days, and or on such lesser time as the court may allow on showing of good cause.
Okay.
So, suggestion.
Yeah.
Because if the OTLA has huge problems with it, that's absolutely
Yeah.
not.
Yeah.
Then it sounds like we should, before the closing meeting off this tape, give the beneficiaries the ability to object to the administration.
Yeah. Well, that's and I guess maybe this is the reason OTLA. Well, yeah, because I guess let's just play this out. If we don't provide for any notice, or even explicitly provide for an opportunity to object after the fact, are there grounds outside of this code for a claimant, for a beneficiary, to bring a claim against the personal representative for breach of fiduciary duty, selling them out in settling the claim cheap?
I think we specifically eliminate their liability under section 8(4) on page 4 and 5.
Yeah, it's released as,
discharge.
yep, once it's discharged.
Well, I mean, I guess I'm saying, but are there constitutional?
Oh, I think there's a due process.
That's what I'm saying. I'm saying apart from this statute entirely.
Well, there is a due process claim, but we also have an Oregon Court of Appeals case that says it's not a property right, so you don't have a due process claim.
Is that what that white case said?
Yeah, it does.
But the legislature.
Well, yeah, but we're talking about current law, you know, trading off one for another. Well, I mean, let's try it.
Yeah, and I can't believe White would survive a later attack. I think White's just fundamentally wrongly decided, period.
All right. Brooks, let's see how you do. Is everyone on the committee okay with this? I assume we are, because we're the probate lawyers. If we can get the plaintiff's bar, all right. If we can do that, I think that makes this a great bill instead of just a good bill.
If I'm a PI lawyer, I recognize that there's going to be some time crunch issues. But at the same time, I represent the PR, and I want to protect my PR, even if it's the wackadoodle. I want to protect my PR, and if I don't give the wackadoodle due process,
Right.
he's not protected.
Well, unless you're going to say, no, we've got to, you know, we don't have to, it's not a due process, right? You're going to fold your arms and say, I'm just going to stand on that.
On White.
Yeah, that's right.
We don't know if we're wrongly decided.
Yeah, so I mean, so that's it, maybe that's it. The you know, the White may be kind of a thin branch for them to stand on.
But I mean, we have the ability to say, if we don't have this prior notice, we're gonna give notice and let them object to the administration.
Oh, sure,
Yeah,
sure. I mean,
think we have to do that.
well, yeah, I mean, I'm just saying that could be as objectionable to other forces as prior notice. So it's not as if it's one or the other. It still could be neither, you know, based on political opposition. But I prefer the prior. And And Brooks, I guess what I'm trying to think from Jim last time, the other concern that the trial bar has is you send the notice and then everybody wants to litigate the settlement.
Yep.
I mean, I guess, how,
I do. But the place that litigation belongs is in front of the probate judge.
I understand.
Well, and at the end of the day, I mean, let's look at this practically. If the beneficiary is going to object and their objection is meritorious, you did provably settle short,
Right.
then whether a court's approved it or not, the beneficiary has a claim against the PR. That's the way it is. PR has a claim against PI counsel for advising them to settle short. That's going to all fall through. And whether that happens before or after the defendant has been bindingly released, the right still exists for the beneficiary to make the claim. It has to.
Yeah, I think that is the thread of argument to make to the legislative committee. Let's see if we do it. Are we, otherwise, how are we on this?
Oh, I have more.
Yeah, go ahead.
So I had a note that, it said bond question mark.
Yes.
So are we waiving this bond or not?
What page?
This is section 7.
Rare occasions where the beneficiary objects. Why don't we also include the option of including a waiver? So in 99% of the cases, the beneficiaries are not going to object, then you can just sign a consent with the petition.
Do we need to be express about that? If I had consent, I would just, yeah, oh, that's right, yeah, that you can,
Yeah, I think it's not a bad idea to put it in this statute because we're dealing with oftentimes non-probate lawyers who don't look at chapter 11, but
I think that's a good point.
we say on a final.
right, oh, yeah.
Absolutely, you have to have consent.
I always assume consent is permitted.
I just think, I think that that's I actually really like that idea. And it may make it more palatable to them knowing it's like we're affirmatively trying to solve your, issues that you think could occur. So we're gonna put that in there and it's gonna allow a waiver and you get that waiver and you don't have to worry about,
All right.
Yeah,
I mean, I don't have any problem with it, because, to me, I think it's just,
And then we trust
saying-
the judges to deal with the wackadoodle.
yeah.
How does that work?
Lane Brooks.
Yeah, Brooks.
I just want to address the bond thing.
Oh, wait, Brooks, before we get there, well, let's finish the waiver.
Okay.
It
Sure, of course.
would be, I think it would be in section 3,
Yeah.
they file notice of time, file notice of time for filing objections, or
Thank you.
a consent, and, a consent and waiver. I mean, look at 111, because it's got language about waiver in lieu of,
The new 111.
oh, do we not have it in there now? Well, okay, I've been doing it all my life, waiver and consent.
Okay.
You're a good guy.
Because I'm a good guy. Okay, Brooks, the bond.
I would strongly argue against a bond for a wrongful death claim, because here we have the backstop of a probate judge who will stop the PR from settling $1 million case for $50, assuming that would ever happen. And further, we have the personal injury lawyer's malpractice policy on board, because anything the PR screws up 99.9% of the time is on the advice of that lawyer. And if that advice is wrong, we have a mechanism. A bond is an extra cost here. And in many of the families who suffer these, we're not going to have any family member bondable. We're then going to have to turn to a professional PR, and that's going to increase the cost of the case and contribute to people not bringing meritorious cases because the costs are too high. Let's not bond it.
I tend to agree. Anybody feel otherwise? Okay.
So in that case, I'll take out this thing about the surety
Yep,
below.
yep.
So I can see as a practical matter I agree with you, but I'm playing devil's advocate. Should there be a bond at the time the proceeds are paid? Or should there be some protection for the beneficiary at the time the proceeds reach the PR?
That's a very good question, and the routine practice that you might wish to codify is that those funds, the gross funds, end up in counsel's IOLTA account pending the outcome of the court's approval of fees, apportionment, et cetera. And if you want to codify that, I'd be comfortable with an attorney not being willing to bet their license on one case.
I don't know, I mean,
Some courts require.
Well, Well, if either counsel's IOLTA account or a restricted account, or you're going to post a bond, because there's absolutely no reason for the PR to have ability to spend wrongful death money other than the creditors who necessarily must be paid, but that can all be done at the time we're writing all the checks. So if it's one of three, counsel's account, restricted account, bond, then we've got flexibility to pick.
I think that's a good solution.
Multiple classes will already require that. I don't know if other courts do. But they have had cases where people have actually, between the settlement and distribution, somebody's going to run off with the money, so.
Yeah, I've seen a case where it was the lawyer that did it.
Yeah, that's it.
Surprisingly, Marion County does not have a policy on that, but it may be because the more sophisticated lawyers are doing it.
Mm-hmm.
So the question I would have though is the client always one of the beneficiaries?
Negative.
If it's not
Yeah.
client's money,
Right.
we can't put that in IOLTA.
The client is the PR.
Yeah, the client is the PR,
Yeah.
so the PR does have control of it, right? I mean,
Once the funds are received, the client is effectively the trustee of those funds for the beneficiary. So I'd have no problem putting that in my account.
I think so. Although there's no,
Can I
otherwise,
Can I chime in?
yeah, who's this?
This is John.
No, John, you're with us, okay.
Yeah, I've been with you all this time. It just took this long before there was something that I felt competent to talk about.
Wait, I want to make a note of the time. It is a record. Go ahead.
I don't know how these things work, but just anecdotally, I know that we have had experiences where, we've had a PR who is trying to close the probate, and the settlement funds have already been distributed out to people without any court approval. And I think that, and that's not the way it's supposed to happen. You're supposed to get court approval, and having to go to court to get approval of something that's already been done.
That's what we're requiring in this group.
Yeah, so I think having some clear requirement that the funds be held in some lawyer's trust account until the court approves the distribution would probably be a benefit, an improvement.
Okay,
Well-
oh, what?
Of course, I'm going to disagree with John.
Yeah, go ahead, it's okay.
Once the court has approved the settlement and the PI attorney's fees, and we're sitting on what I'll call the net pile of money, if
Right.
the PR pays all of the creditors required to be paid under 030, and all the beneficiaries are competent adults, I continue to say that no court has any say in their voluntary apportionment between themselves by agreement of the funds.
And
So
that's in,
in that circumstance, checks could be written, and then the PR says, here's a receipt from everybody, they're all happy, I'm done.
Well, I don't think we're saying different things.
Okay,
You still gotta get the settlement approved, right?
correct. And the PI attorney's fees and my fees.
Yeah, so until those things get approved, the fund should be held in somebody's trust account.
I don't disagree. We're saying the same thing. I just didn't hear you that way.
Yeah, and then, I know you just like to disagree with me, but that's okay.
That's
And
correct.
then, after that's happened, then either once they agree on the disposition or once the court orders it, then it can be distributed. That's the same thing I'm thinking.
Okay.
yeah, and in fact, 30040 already says, except when all beneficiaries otherwise agree. If settlement with or without action is affected, there's more than one beneficiary, the amount to be distributed to each beneficiary shall be apportioned by the probate court. So it already allows consent.
Yep, cool.
So what are we saying here then, and where do we put this?
Well, I guess one question I have is, it sounds like all the requirement for apportionment is in chapter 30. Do we need to have something in this process reminding them that, oh yeah, the court has to approve the apportionment?
Well, I think the court has to approve the apportionment if at least one of the beneficiaries cannot consent because they're a minor or incapacitated, or if at least one of them doesn't agree, then you've got to have a trial or at least court approval.
And that's all under because of chapter 30. And so Jennifer's question is, do we need to say that again in this, LC wouldn't like
The
that.
petition has to state the amounts of payments or reimbursements owed under 30.
But we
Yep.
took out,
That's,
but remember, we took out.
That's not
the
apportionment.
petition was, was
We just did
also
the three.
included the apportionment, and we took that out.
Oh, that's right.
And so I'm wondering if we need to have some process in which the court either blesses the apportionment, or there's some
well, that's exactly what 30.040
So
says.
that's all handled in.
Yeah. Yeah. So
I don't think we need to say it again.
I don't either. Because this all is against the backdrop of chapter 30.
Yeah, under section 2.
Yeah.
Like, if you don't know that those statutes are there, then you're really in trouble.
Yeah, that's true. Then what the hell are you doing? So.
And of course I'll pop up and say I've tried that case, but let's go on.
Yeah, right. So then the issue of the funds being held in this is where you could say it actually, be held in the attorney's trust account until distribution to the beneficiary is apportioned according to 30.040 or something like that, and just cross-reference, just a crosswalk to 30.040.
That's maybe in section 4 on page 2, I think, because in section 4 on page 2, we talk about the bond requirement, so we can just put it all there.
Except that
That's
section.
That's not wrongful death.
That's not wrongful death, that's everything. That's if it's a personal injury claim. No, it does, and if the petition for appointment is filed under section 5 and no assets.
Yeah. Oh, we already have a bond.
It says defer until settlement, but we were.
That's personal injury, that's not.
No, it's both, because the section 5 is for wrongful death.
Yeah, but number 1 says defer bond requirement until a settlement of the personal injury claim is approved.
Section 3 says court approval of settlement of personal injury or wrongful death claim. And then section 4 says file under 5.
So this needs to be fixed.
Yeah, I think we take out wrongful death out of section 4. Because it has its own waiver.
Yeah.
Section 7 will cover the waiver of all the wrongful. Yeah, so let's take wrongful death out of 4. And then section 7 is the waiver of requirements in wrongful death only cases.
Section 4 has 2 parts. One is the deferral of the bond,
Mhm.
the other is accepting annual status reports in lieu of an annual account. I assume that if you only have a wrongful death claim,
Yeah.
I'll
you
copy
would
that.
want the same opportunity to do a status report in lieu of an
Yeah.
annual account. So,
And that should go in 7 as well.
Yeah.
okay.
Yeah, so we take out the reference to wrongful death in section 4. And in section 2, we add language in section 7 that incorporates that. So let's get back to bond.
Wayne,
Yeah.
can
Yeah.
I just ask a question real quick? I'm just backing up under section 3. The last sentence where it says, the petition need not state the amount of the settlement, but 2E says that you have to state the amount of the settlement in your petition.
That's for the declaration. It has to.
Yeah, that's the declaration that accompanies the
Oh, the
petition.
declaration, sorry.
Although it's curious if everyone's getting notice, what's the point in not saying the amount in the petition?
I think that, didn't we do that as an accommodation to OTLA because there was a case where they wanted to keep it
Okay,
privileged? They could then just refer to the affidavit.
except for all the beneficiaries who got copies of it, but.
Well, I think there was, the other aspect was the other legislation that makes
Yes,
those
right,
declarations confidential.
right.
So a third party couldn't go down to the courthouse and
Right.
find out.
Yeah, okay.
Also, on that part that makes it confidential, is that gonna be a problem where we're at requiring that to be part of the notice? Do we need to undo that or make an exception or something?
Yeah.
We talked about that a little bit. My feeling is that
the confidentiality is for the court records, that, it's essentially it's under seal when you file that with the court, and only obtainable, I think the language was only obtainable for good cause.
That's right.
But I don't see how you can deny that to the other, in this context, what I would call parties to the case.
The beneficiaries, yeah.
Parties, but,
No, they're not.
beneficiaries.
Yeah, I don't think you need, like, everybody needs to keep it confidential, it's a confidential
Okay,
record.
yeah, okay.
Yeah, I agree.
So let's get back to then, what are we going, where and what are we going to say? Okay, in section 7, we can just waive the bond. We can add the waiver of bond to section 7, just flat out waiver. But we need to add language in, about the lawyer's trust account, and help me and Marissa what that says.
Until the settlement is approved under the thing.
Yeah, I guess, is it when proceeds of the claim settlement are received, this is conceptual, they will be deposited to the client trust account of the attorney for the personal representative, or is it the personal injury lawyer?
And attorney for the personal representative, it could be either place.
Or
Exactly,
okay,
just
or,
attorney
that's
for
fine.
PR.
But does that one, do we want that to go under waiver
Or is it just not
requirements?
and?
No, this is a different section, yeah, it's a different section. We're putting the bond in the waiver of requirements under 7. So this is when the proceeds of a settlement of a claim are received, they will be deposited to the client trust account of the attorney for the personal representative, or the
An attorney for the, yeah.
an attorney for the personal representative?
You either have your probate attorney.
Okay, and then you think, okay, rather than say the PI lawyer or the probate lawyer, just say an attorney?
Yeah.
What if it's my business lawyer? No, okay, because you're.
An attorney, IOTA, or a restricted account, or.
Wait, it's gonna be deposited
Okay.
to the lawyer's trust account.
I'm sure we can talk about that somewhere. I'll find it.
So the attorney of record?
No. Other than the same obligation.
The PI lawyer may not be of record, he may not have filed it.
Yeah, that's true. So, to the client trust account, and then, what are the other, Heather, you were saying, or to?
When we were talking earlier, we talked about depositing it into an IOTA.
Right.
They can get a restricted account or imposing a bond. Those are the 3 options.
We call it a lawyer trust account.
Yeah, I don't think we would
Yeah.
describe it as an IOLTA account,
Yeah,
that's
no.
just a bar arrangement. A lawyer trust account. Is there a reason for a restricted account?
Well, one of the reasons you might want a restricted account is, let's say you have more than $1 million and you don't want it in, Pioneer Trust Bank at 0.001%. Instead, you want to put it in a Fidelity account that's 0.05%. I can see reasons.
Brooks?
Yeah, I would like to retain that flexibility, because recall, if we have an apportionment fight, those can sometimes take close to a year to resolve, and I agree with whoever's comment. If we're sitting on $1 million, I want that in a restricted money market or other interest-bearing account for the benefit of the beneficiaries.
Okay.
Or, I don't know what a restricted account is. I have no money.
I have no money.
Well, it's dealing with other people's money problems, an account that cannot be accessed without a court order.
Isn't there,
UTCR 9.050.
what is it?
UTCR 9.050.
Okay, so there's your language?
Yeah, I'm
Okay.
going,
9.050? Yeah, 9.050. Okay, so there's your language. So it's a lawyer's trust account, or on motion, it's 9.050, incorporate that. I mean, you gotta have approval by the court, right?
Right.
To do it in a restricted account?
You can have a court order.
So you're not investing it in, money market or something like that.
Well, and the order establishes the restriction.
Yes, right,
They have-
upon motion and order of the court, a restricted account as, the come up with language from the rule. But we want motion and order of the court. And the third one is
Bond.
a bond. Do we need a bond with those two other options? When would you use a bond instead of either a lawyer's trust account or a restricted account?
In practice, I think most PR counsel want to avoid the bond because of the cost.
Yeah, yeah.
And I, as creditors counsel, am usually okay if they want to substitute a restricted account.
Brooks, do you see any reason for adding a bond as a third option?
I don't, as long as the account's restricted or the attorney has control, either of those feels equivalent to a bond. We do it in probates all the time that way.
Yeah, okay.
Okay.
Fine with me. So that becomes a new section 8, I guess.
Okay.
Or,
So I guess the only thing would be, these are never funds that we're going to want to have some kind of quick liquidity with to pay off something within a shorter period of time than getting a judge to sign off.
Well, those have already been paid.
Okay.
Those-
I thought that's where we were, I just wanted to
Yeah,
make
all
sure.
the medical liens and all that gets paid, attorney fees get paid, and there's this chunk that's left to go to the beneficiaries, and that's what we're talking about, right?
I don't know, is it always the case that, Brooks, help us out, yeah, at what point do these funds go into the trust account or the restricted account? Is it always after, liens and creditors entitled to payment under 30030 have been paid, or, would there be times where you're working those out and you need to park the money in the account while you're working those out as well?
Yeah, and you're exactly right. It happens both ways. And this gets back to Jim Hughley talking about, and my concerns last time about don't make me make admissions about how much I owe because I want to negotiate.
Right.
It happens both. Yeah, it happens both ways. So if we can maintain flexibility, I mean, if it's drafted in a way that, for example, if we know the creditors think they're owed 50 and we want to talk them down, maybe we put everything but 50 into an interest-bearing account pending apportionment, throw 50 in the trust account so the lawyer can spend it, and then the lawyer, spends 35 and throws the other 15 into the interest-bearing account. Down the road we go. If we could preserve that flexibility, that'd be useful for the boots on the ground lawyers doing the work.
So we want this option not to be exclusive, that is, not one or the other.
Either or.
Yeah, exactly.
Yeah.
And if we could make it, yes. So the more flexibility, the better.
So help me out, in terms of how we phrase this. You got approval of the settlement. Do doctors, does Rick, and others get paid before these funds come into the lawyer's trust account, on occasion?
Rick doesn't get paid.
Yeah, I do. If we paid the medical
Oh,
bill,
okay.
Right.
associates.
Yeah, right.
But prior, okay.
Yeah. So, I don't want to create a situation if it's happening and it's easy and it works for everybody, that some of these funds are just distributed straight out of the settlement to claimants under 030. I don't want to have to add an extra step where that money first has to get into the lawyer's trust account or a restricted account and then get paid.
Why don't we just phrase it as funds received by the personal representative?
Funds received.
Lane Brooks.
Yeah, Brooks.
I'm actually going to strongly advocate that all of the money, even money we all believe goes to Rick or OHSU, do go into the lawyer's trust account. Because if we leave, and this is what I've seen, if we leave flexibility for the money to go from the settling defendant directly to the creditor, that cuts off a lot of our leverage to negotiate with the creditor on behalf of the family who suffered the loss. If we've got all the money and we the PI lawyer, are the only way they get paid, that maintains our leverage, doesn't allow us to not pay them. But if you give leverage for the defendant to directly make payment, you're going to have defendants saying, we will promise to take care of your liens. Then they're going to go negotiate and keep that difference if they successfully cut the lien down, and that should belong to the family.
The only problem with that is under Oregon's current, personal injury lien statutes, it expressly states that the defendant is to pay the state's lien in full before dispersing money to anybody else.
Well, Rick, I'm going to tell you that statute, I'm sorry, go ahead.
We haven't been enforcing it the way we probably should, but I'm just telling you that that's already there.
Well, and I'm going to tell you, I do not believe that that statute applies to wrongful death cases because, as I've said before, the PR has an affirmative obligation to come to you and offer you money, as opposed to personal injury liens where you've got to assert a lien to make sure you get paid, et cetera, and then you have the sub-row fight. I think wrongful death's in a different place. I don't think you have a lien because there's already a statutory duty to pay you whether you know, the PR has to offer you money even if you don't ask for any. And I think that's a different category.
But I want to, so you're saying that in all cases, and I think it's fine with me, in all cases, the settlement proceeds go to the lawyer for the claimant.
Yes.
And all of the obligations under 030 and all of the attorney fees and ultimately the apportioned shares of the settlement to the beneficiaries, all of that gets paid out of the lawyer's trust account or the restricted account.
Yes.
That seems to make sense.
I think it makes better sense if we're not gonna file a final account, because that lawyer has to keep an accounting of the ins and outs of the trust account. So if we're eliminating the final accounting requirement, there needs to be some bookkeeping safeguard, and that happens within the IOLTA.
Or in the restricted account.
Correct.
So then we would need to make a conforming amendment to the statute that
Well, not if it's not, Brooks just said that's a personal injury statute, not a wrongful death statute.
Well, I don't know that I necessarily agree with Brooks's analysis. You know, that's something that we can litigate in due course.
Well, let's look at the statute.
What?
Well,
Or else-
416.540 is the lien statute.
Matt, you were gonna, well, if someone looked that up and then Matt, you were gonna.
Brooks, this is Matt Trump. My thought was, as a practical matter, the PR is always coming to the terms of the settlement with the defendants of this claim, you know, long before there's involvement of any of the parties that are owed for medical expenses. And if you, as PR counsel, don't want defendant paying any of the medical providers directly, isn't that a term of the settlement? I mean, you just identify, I mean, I often will see the other way around. The PR has agreed to indemnify the tortfeasor from any liens, saying basically it's PR's obligation to resolve all those liens. So isn't that just a term of the settlement? I don't think we're giving those medical providers any leverage by, we're just trying to retain the flexibility for PR to do however they want to structure that payment of claims and receipt of funds.
And do we leave flexibility, and Matt has suggested it, do we leave flexibility if we say settlement funds received by the lawyer?
Well, the point I was making is I don't want our statutes to be interpretable by a defendant to say, I, defendant, will promise you I will pay the medical liens, therefore from the gross settlement we've agreed to, I'm going to deduct the current amount of the liens, then I'm going to go negotiate and I'm going to keep the reduction I get. I don't want a defendant to have that right in the change you're making in the statutes, because I don't think they have that right now.
Well,
isn't that just a term of your settlement?
Well, I was going to say, yeah, that would be.
Fixing an amount that you're going to resolve the claims at, and if they say X minus 100,000 because I want to go settle the liens, then your response is no, X, and I'll take care of the liens.
Unless you think, okay, in which case, so Brooks, what?
No.
And under.
Wait, Gretchen, go ahead.
Under it's 416580 is the actual liability, obligation to pay. And it says that, anybody who makes any payment to the injured recipients, the heirs, personal representative or assigns, or their attorneys, under a judgment, settlement, or compromise without previously having been paid or is personally liable. So under our statute, we're only become obligated once there is an actual judgment, settlement, or compromise. So your scenario where you haven't yet settled, we're not going to claim that we have an obligation to be paid until you have an actual judgment, settlement, or compromise, and that's going to contain whatever terms you want it to contain.
Right.
Okay.
So.
And just, go ahead.
Yeah, so I guess my question is, do we need to disallow what you said you don't want to allow? I mean, because it's all part of the negotiated settlement, isn't it?
Well, let me be clear. I think you are creating a leverage point for defendants, paying defendants, that I don't think they currently have, because under 030, the PR currently has the duty to go find these people and pay them. If you create that piece of leverage, the defendants are going to use it, and the benefit of the negotiation could flow to the defendant, and I, as a matter of policy, don't want that to happen.
Okay, I hear you. Kathy?
Oh, I'm just agreeing with Brooks. I work with those PI attorneys in Carroll, and I mean, traditionally, the gross settlement
Yeah,
goes.
that's been my experience. That's been my experience.
And then we take the net to divide among
Mhm.
beneficiaries.
And pay the creditors out of the funds when they come in.
Yeah.
All right.
Well, and I'll tell you, just as an FYI, there have been cases where when we're dealing with a troublesome PI attorney, we have gone and sent a letter off to the defendant and said, look, you need to be aware, we've got this statute, and we are prepared to foreclose against you, defendant, if you pay out the money. And I mean, we've had hearings on those in the past. So, I'm not willing to give that up, because I understand what you want, Brooks, and I don't want to undermine what you're trying to accomplish, but I'm not going to give up whatever rights we have when we're dealing with a PI attorney who's trying to use that in a fashion that I think is abusive.
All right, Ken, is this a place where we can use Wally Carson's artful ambiguity? That's where he said, where in committee, one side says it's got to be, the number is 5, the other side says, no, the number's got to be 1. Then they compromise by saying some. Can we just say the proceeds received by the attorney and just leave it at that, and not expressly create anything, but also not expressly eliminate anything? Just say the proceeds received by the attorney go into the account.
So when proceeds of
Sure.
wrongful death claims
Yeah.
are received by the attorney for the personal
Yep.
representative and wrongful death.
Yep, how about, are you guys okay with that?
Shouldn't it be are received by the personal representative? Because the
Are
attorney.
received.
Are received.
Or received.
There we go.
So that-
Artful ambiguity.
I'm really good at that.
Yeah, I think that we'll just leave it at that and not answer this question, whether you have to or whether Rick has the right to go after the defendant. Yeah, it will be, yeah, but let's just say, let's not pick that battle. We don't have to answer everything in this damn statute. When the proceeds are received, they'll be deposited to the lawyer's trust account or to a restricted account. Okay? Done. Anything else?
I think that was it, that's all
Okay.
I had.
So I have a few little kind of small things.
If you promise.
They're small, they are. So, one of the things is in several places, it either says deliver or mail or deliver or mail certain things. And in our chapter of 111 that we're working on, there may be another method of notice that the committee might want, as email or whatever. So I don't know, maybe we wait to do that.
I think we would, yeah.
Until we figure out
Yeah.
chapter 111, but and there are places where, like on page 4 in the bottom of page section 3, it just says that personal representative shall mail a copy, whereas these other places they deliver. So it's an inconsistency.
So was there an intent in the differences?
Probably not, either I copied it from
Yeah,
someplace
right,
else,
right.
and that they're different.
I think mail or deliver would probably, for
Why
now.
do we want to do that consistently?
Yeah, mail or deliver, yeah.
Okay, Then on page 4, near the top, we have that clerk's file number issue
Yes.
again that we want
Oh.
to correct.
Yeah, okay, good catch,
So
yeah.
where's that one?
That's on top of page 4, it's A, subsection 6.5A.
Then on section 8, subsection 2, we're doing this, it says the motion must state that no assets of this estate have been discovered as a reason for closing.
Yes?
And don't we also want to say, and that the person, and the purpose for opening the estate has been accomplished or something like that? Maybe we don't need to say that, but it just seemed to me that.
Well, but we're adding in 1 that this is done after the distribution has been made.
That's the timing, correct?
Well, and it's after distribution, so I guess I would assume that
Okay, then maybe
that sort of takes care of the purpose. You're saying we've distributed everything, and we haven't discovered any other assets. To me, that takes care of that.
Oh, so you have to state.
Yes.
It says the motion must state no assets of the estate have been discovered. And so are we
Oh.
adding anything to that? And
I see, yeah, I guess,
maybe it should state, and
And the wrongful death claim has been resolved and the funds have been
right,
distributed.
okay.
and all funds have been distributed. So it seems like there's more that needs.
Okay, you're right, because the section 1 is a timing thing, you're right. It's not what the motion has to say. Although, anybody filing it would do that, but, you're right.
And then in section, on that same page, section 4 near the bottom, in a couple of places refers to surety. And
Right, we're taking that out.
Taking that out.
Yep,
And then on page 5, section 10A, it has cause of action, and I think we said we were gonna call it claim.
Yeah, you're right.
And then the only other thing I had was, at the bottom of page 5, subsection 2, is this consistent with the change that we made about the valuation of the inventory? You know, we changed that
Right.
before that comment, and I don't know.
yeah, that's an LC thing, we won't amend that statute in every, in all the bills.
Oh, okay.
It'll just be amended once.
Okay, all right. Then that's all I have.
Okay, all right, good, very good. All right, so I think we're done with this one for today. Well, okay, good. Let's move on to, number, 2957.
That's the date, 10/23.
10/23, yep, let's move on to, and Brooks, thank you for your offer of help with, our friends at the, plaintiff's bar. We'll be anxious to hear, how you come out.
As soon as I know, you'll know.
Yeah, okay.
Well, Bonnie Richardson, I think, offered to also help out with that kind of.
Yeah.
And she's playing it as well, okay?
Y-
That'll-
Yep.
Yeah, and Bonnie was gonna call in late, so she's not with us yet, so,
Do we need
too bad.
anyone to deal with the defense people, or, I don't know.
I don't,
No.
Or they're not gonna.
yeah,
Okay.
no, that's right, this is, they'll just pay up. Yeah, the rest of this is on the other side of the fence. Okay. Yeah, Brooks.
I was gonna say, if you're done with wrongful death, I think I'm gonna take off.
Oh, okay, yeah, we're done with wrongful death. Thank you very much for your help.
See everybody, bye.
Appreciate your expertise. Okay, 2957. This is the, no asset probate. So, let's look at this. Section 1, subsection 12. We looked a little bit at this last time, but let's walk through it. If the petition states, this is on page 2, that no assets of the estate are known to the petitioner, under subsection 11, a statement of the purpose for filing the petition, okay? So that goes in the petition of a no asset probate, okay? Then on page 3, this is the bond statute. Subsection 2 of the statute says the bond requirement does not apply if, then we have the bottom of page 2, if the will says no bond, or if the PR is the sole heir devotee, or if the PR is DSL, or DVA, or, so then now we're adding, or, so this is no bond. If the petition for appointment of the PR states that no assets of the estate are known, and no assets of the estate have come into the possession or knowledge of the personal representative. I guess we had a question as to whether or not we need that and no assets of the estate have come in, because this happens at the filing of the petition.
That's right, that's what we, I mean, yeah, I think you could take that out if that could never happen.
Because the petition would ask for a waiver of the bond.
Right, okay.
Yeah. So there is no intervening time when we're dealing upfront like that.
Then this 3 is changed at 9, so,
Oh, tell us about
yeah,
3.
so 3, now I had, if the court has issued letters under 2D, which is not the right language probably,
Right.
but anyway, that's what I have.
Okay,
And assets of the estate later come into the possession or knowledge, the personal representative is going to provide a bond.
yes, yes.
And Jennifer fixed this language for me too. Within 30 days after filing the document, or showing up to the estate, I think is what we came up with.
Oh.
Yeah.
Okay. Yeah.
I need Jennifer to.
Because
edit all
that
of
could
my
be,
things.
because that could be an accounting, yeah, okay,
So that paragraph is revised.
yeah. But those are the conceptual revisions, and I think that's agreeable to us. The only question, and I raised it last time, and I think we all agreed we don't want to go there, right, is, remember, this is supposed to happen before letters are issued. Obviously, in the scenario under subsection 3, letters have been issued, and now you've discovered assets. I don't think we want to say that on the discovery of assets, the letters are void, because then nobody would know if the letters are ever any good. This is just gonna be something that the PR has to do. Okay?
Fiduciary duty.
Yeah,
If we're doing this way, we need to change the numbering in, going back a page to 1A. The except is provided in subsection 2 to 4.
yeah,
I believe we now want that to read 2 to 5, since we inserted an additional subsection there.
Okay, well, I will.
oh, I see.
Yeah.
Okay, yeah, good point. Good point, yeah.
I'm sorry for my faulty memory, but I think on subsection 3, that we imposed, when we discussed it, we imposed on the personal representative an affirmative obligation
Yes.
to file an inventory or supplemental inventory, which is different from a standard PR where you can file an inventory, an amended inventory, or you can advise the court in the first annual accounting of the.
Oh, that's in section 4. If no property of the estate, oh, no.
I'm talking about when assets come into the possession, I thought that we had imposed an affirmative duty.
Yeah, we have.
to file those.
We did, I think, but that's under the.
Yeah, right.
I don't know about that.
Yeah, okay, it's in subsection 5.
Okay.
Sub 2, if the petition says no assets and assets later come in, the PR shall file in the estate proceeding a supplemental inventory
Okay.
within 30 days, although that's not necessarily, because they could come into possession before you file the inventory.
Well, no, because your first inventory, this inventory is gonna state that there are no assets at some point, right?
Oh, right.
Right.
Yeah.
Because that section 5 is about a supplemental inventory. Same thing. And then the section 4 is about the initial inventory.
Okay, and that's couched in, if no property has come into possession, the PR shall file an inventory. So the inverse of that is, if you have come into possession, then you have to include that in the inventory. Okay,
Right.
and that'll capture it, you're right. So that takes us back to the language, though, of
Okay. Yeah, that's
subsection,
all. Yeah.
that takes us back to the language of subsection 3.
I knew we had done it somewhere.
Yeah,
And just conceptually, does subsection 3 belong here, or does it belong with the requirement to file the supplemental inventory, and then you're required to file a bond with your supplemental inventory? Because 1 here is saying you don't get letters and you can't
Right,
act
right,
until you have.
right, that's right, right.
So talking about getting a bond at a later point in the process.
Well, except we're saying that we're adding because 2 is all the exceptions to
Right.
1. And one of those exceptions is,
You don't have any
you don't have any assets. And, yeah, so Marissa, what do you think? Where does it belong?
So we would have, we could put everything in one section, that if you come into the into the, find the stuff later, and here are all the things you have to do.
The heading for that section, at least in the prior statute, is necessity and amount of bond exception.
Yeah.
Yeah, we don't have, in this case, like in section 7 of the wrongful death, we don't have a single section that is all the waivers.
Right.
So I think the waivers are built into each of the statutes requiring the elements.
Well, that's how I did it.
Yeah, because otherwise we'd have to substantially rewrite this. Because this is going into our regular 114.
Right.
Or 113 rather, yeah.
Well,
So I think we have to include those, I think we have to include those after requirements in each of the sections where we're exempting the requirement.
otherwise, it's gonna be more like a big bold section, which
Yeah.
is kind of what we were trying to avoid.
Yeah.
Yeah.
Yeah, so that's a style thing, but I think it makes sense in this case, since we're not creating a specific statute just for no asset cases.
Admittedly, this is probably a dumb question. I know now when we file a supplemental inventory saying we have more stuff, the court requires us to increase the bond. What statute is that tied to?
I think that might be 113, 115.
Oh, yeah. It is there.
Because it would make sense to put the requirement to add, that requirement that's currently the big sub 3 in section 2, would make sense to go with the requirement for increasing the bond in a supplemental inventory anyway. And do we need an actual new law adding that requirement?
Yeah, because you don't have a bond to begin with, so we're not increasing the bond.
I know we talked about this before, I don't remember what the content is.
So that's why I think the increasing the bond doesn't work, because you don't have a bond to begin with.
The court may impose, waive, or reduce. Court may impose a bond, yeah.
I mean, it could, if we want it to be in a new subsection of 113, 115, that's fine too. Of course, when you set the bond for the first time,
Right.
Well,
then there's all the stuff about what you're supposed to consider when you set the bond in the previous section.
But it says court may increase or reduce amount of bond or require a new bond. If it appears that the bond was inadequate.
The bond, yeah,
or
see,
a new bond is
That
necessary.
presupposes there is an existing one.
Yeah, I don't think this goes there. And I mean, it's just, so this is really just a style question as much as anything. And in every other one of these, we've included that, but if you find it afterwards in the statute that creates the exemption, so that it's all there together, and I like that.
I kind of like that it goes with it, because
Yes.
it says the bond has to comply with this section.
Right.
It's a brand new bond, here are all the requirements,
Yep.
they're all in this section. I like it here, but
So it's not a stupid question, but we're not going with it. Okay, so are we clear on section 2 then? Section 3. This is notice to interested persons, publication. So here again, we're creating an exemption and the exception to the exemption. Sub 5, the section does not apply if it's a no asset case and no assets have come into possession. And that's fair because publication, there is an intervening interval of time between filing and publication, so that's good. B, if the petition states no assets are known and assets later come into possession, the PR shall within 30 days after this. Do we want to tie this, like we did the bond, to filing of the inventory? Let me go back to sub 3 on page 3. I think then, in light of what we did in subsection, in the inventory statute, I think inventory or supplemental inventory is correct. Because we're saying if you discover assets, you file an inventory or supplemental inventory. So document would not.
there were some more things that Jennifer thought would have been added in there, and that's why.
There could be an annual account.
Then we need to go back and we need to change, because what we're saying is within 30 days, you've got to file. I think because of that 30-day requirement, I wouldn't put it in an annual accounting. Yeah. Because the annual accounting is, you kind of catch up with when you file it. Here, we're saying, no, you got to act now.
Okay, so then that inventory, supplemental inventory,
That's in, that's
Page 5,
page 5, yeah, top of the page.
subsection 2.
This is the,
file was, right, okay, so there wouldn't be.
yeah, I don't think we want,
Accounting, they would have to file either
Yep.
an inventory or a
Yep.
supplemental
Yep.
inventory. Okay, so it should be.
yep, so that makes the language on page 3 okay. Inventory or supplemental inventory, because that's what we're saying they have to file. It's exactly why, you're brilliant.
There we go.
Okay, so then on to, yeah, subsection, page 5, or sorry, page 4, 5B. So instead of 30 days after discovering, shall we key that to 30 days after filing an inventory or something, so we have an event? Yeah. Same as the bond requirement.
So filing the inventory or the supplemental.
Yep.
Inventory first showing the assets.
Yeah.
Yep.
Okay.
So it's parallel to the exception to the bond
Might
waiver.
have to change that a bunch of times, so.
Yeah, well, let's see.
Say that again, though.
Oh, it'll be within 30 days, and then it'll be the same language as we have on page 2, within 30 days after the filing or of the filing inventory or supplemental inventory first showing assets of the estate.
And then they need to commence publication.
Right. Yep.
So you have 30 days after discovering the item to file an inventory listing the item, and then you have 30 days after that inventory to publish and get a bond.
Yeah. Let's see, section 4, this is, the inventory, if no property of the estate is put into possession, the PR shall file inventory stating no property of the estate. Okay, so there's your 0 inventory. Section 5, if the petition states no assets, and as it's later come into possession, PR shall file it in the estate, supplemental inventory within 30 days after the receiving possession or knowledge.
We need to refer to the filing of the inventory in that.
No, this is the,
Right, but I mean, the petition states it, and the inventory states 0 assets.
Yeah, we already talked about that. You could have a petition that says 0 assets, and by the time you file your inventory, you got to declare.
But, right, but that's section 4.
but section 5, look at sub 1, it's already predicated on when property not included in the inventory comes into possession.
Oh, okay.
Yeah,
I don't like this after the date of receiving.
I don't
possession or
either.
knowledge, but I'll, or you can give me a suggestion now.
okay, so, but let's talk about knowledge, is that the appropriate, whatever that word is, for filing an inventory?
Well, the statutes don't always require the person.
Well, receiving possession or knowledge is the language in the existing.
It is, yeah, okay, that's why it's there, yep, that's why it's there, good enough. What's wrong?
Borrowed or.
Ain't broke, don't fix it.
Yeah.
Huh? Ain't broke, don't fix, that's right, yeah. Yeah, so, interesting, receiving possession or knowledge might be just fine.
Well, I got it from somewhere else.
Yeah.
I came up with that.
You could say of the assets, I mean,
Oh,
you-
receiving, after, the date of receiving, after receiving possession or knowledge of the.
of the assets, yeah, if you just wanted to end on
Yeah, I
a
like
little
that.
bit more complete kind of sounding
Okay.
sentence.
Well, in section 5, the first section says not included on the inventory.
Right, so we filed a 0 asset inventory.
Right, but section 2, where we're referring to that, it just says the petition, and then assets later come in. It doesn't refer to an inventory.
Oh, that's
That's
interesting.
fine. If the, yeah, if the inventory originally is the.
Yeah, if the inventory states there are no assets of the estate. That's a good point, yeah.
Hey, Lane,
John?
I think we now have 3 requirements to file a supplemental inventory. In the back, we were just talking about the bond section, you know, you got a requirement to file a supplemental inventory in the bond section.
No, that just refers to the trigger for filing the bond. That's not a,
It also creates an affirmative obligation to file a supplemental inventory.
no, the affirmative obligation is created in section 5.
It says within 30 days after filing the supplemental inventory. I mean, I guess I could put under that section, if that would help you out, but.
Yeah, the only place that that requires the substantive requirement for the filing of a supplemental bond, inventory is subsection 5.2. Everything else refers to that as a trigger.
So D3 does not require the filing, it just references the filing.
That's right.
So a cross-reference might be kind of helpful.
Okay, yeah.
So I think, in section 5, 113, 175, sub 1 and 2 are redundant.
Well, that's interesting.
What page is it?
Well, okay, John is asking whether we need number 2. Let's,
The difference.
One already covers it, because if you file a no asset petition
Right.
and find assets before you file the inventory, then the inventory's got to include the assets.
right,
If you file a no asset inventory and you later find assets, sub 1 requires you to file a supplemental.
This was supposed to say that you can't just include it in the next accounting.
Oh, right.
Yeah.
And that's the last part of that one is.
oh,
Did you hear that, John?
Okay, that's the difference, so. can't we
yep,
just,
that's right, that's right. Yep, okay, so that's right. All right. So then we go on.
There's gotta be a way you can make one section say that.
Harder than it looks.
Yeah.
Try.
Go for it, John.
Yeah. All right. Yeah, subsection 6, I think that's fairly straightforward. This is, notice to creditors.
Hey, wait a minute, I still got another nit on that.
On which?
On section 5.
What?
Sub 2, I still don't like sub 2. If you file a no asset petition.
Except now we're gonna change that to say if you filed a no asset inventory.
Oh, okay.
Well, you would add, and.
Okay, I think that satisfies my concern. Okay.
I don't know that you need to say both, because sub 4 already says that if you if no property has come into possession.
You could have a regular probate that has an inventory with 0 assets. Theoretically.
What?
You could have a regular probate that has an inventory with 0 assets.
Explain to me.
Well, I don't know, I just think there could be a situation where.
But we're creating this for the estate that has 0 assets.
Exactly, so what I hear you wanting to do in subsection 2 at the top of page 5 is
Yeah.
take out the part that says, if the petition for appointment
Yeah.
of the estate.
Right.
Take that out and only say if the inventory states there are 0 assets. And I'm just saying, is it possible that in a regular probate, you could have, have the inventory say there are 0 assets, in which case they would have already done this.
Huh?
Only if you're screwing it up or you're a masochist.
Essentially, you'd have to file a petition under the belief that there were assets,
Right,
and then discover that there were not.
right.
But I feel like once you discover they're not assets, I would imagine it would be the intent of the group to allow that to then fall down into the no asset probate rules until assets are discovered.
And you ultimately just file.
In here, and maybe they'd amend the petition to to.
Right, yeah, I don't think we need to create that path.
I mean, at that point, haven't they already done most of this? If you filed.
Yeah, right.
There was assets, you probably went ahead and published notice, sent notice, and we don't need to try and give them authority to undo those.
Right,
They've already done it.
right.
It was just their mistake that they thought there was assets when there wasn't. And then if they, at that point, file an inventory saying there's no assets, most of the time, aren't they just gonna be at that point seeking to close because there's nothing left to administer?
Which is why subsection, if you look at section 4, it does not have the introductory clause, that's brilliant, Marissa, does not have the introductory clause if the petition states that no assets are known to the petitioner. This is just if no property estate is committed to possession. So you filed the estate assuming there were assets or believing there were assets, so you didn't allege that it's a no asset case. But you don't have any assets. This allows you to file a zero asset inventory. I like that.
Where are you reading that?
So that's on page 4, section 4. It doesn't have the predicate if you have filed a no asset petition. This is in all cases. If there's no assets, you can file just a zero asset inventory.
Like you find out that there was a POD or a JP.
Exactly, yeah, that money that you thought, that's right, was the estate fund.
Quick escape route.
You file a zero asset and then you can carry on, as a zero asset estate.
Yeah,
Well,
not
unless,
waiting for your PO.
yeah, and let's make sure we do that.
Yeah, I think you're right, you can just get rid of that data language. Because if there are no assets either way, and then assets later come in, then you have to.
Right,
In Trump County, you can already do that. You can just say, no assets were discovered and you dismiss the case.
so let's go back, I think this is helpful, let's go back to section 3, sub 5. No, okay, no, because there that you've got the predicate, no asset allegation. What if you filed and before you publish notice, you discovered that that account was a POD account and you don't have any assets?
You can amend your position.
Oh, there you go. Okay, yep, that's how you do it. Okay, yeah, that answers my question. So I think we're okay then. Let's go on to section 6. PR is not required to give notice to creditors on account of a claim that's already been presented. Oh, wait, that's okay. Yeah, that's really not related to the no asset.
Oh, this little, the first.
Yeah.
Yeah, no, that
No,
was
it's
just
not.
because
Okay.
that sentence is really-
Oh, there it is, in 6, there we go. This section does not apply if the petition states that no assets are known and no assets have committed to possession. Okay, there's our predicate. If the petition, and do we want to because this could happen before the filing of an inventory. So if the petition of the PR states that no assets are known and assets later come into possession, the personal representative shall comply with this section. The 3-month period for compliance begins on the date of filing the inventory. Okay, it's the same trigger as we've got for everything else. Okay? Section 7, this is presentation of claims, except as provided in subsection 5, okay, and 5 says, if again we're in a no asset estate, the PR has no duty to allow or disallow claims presented. If the petition states that no property are known to the petitioner and assets later come into possession or knowledge, a claim presented before the filing of the inventory.
And here we need to add supplemental.
Or supplemental inventory, yeah.
Or supplemental inventory for showing.
Yeah, that's right. For filing inventory or supplemental inventory first showing assets of the estate, yeah. Shall be considered as allowed as presented unless within 60 days after the filing of the inventory or supplemental, that's, yeah, came in. Oh, that's where that language should go.
What language?
The language for showing property of the estate, it should go the first time you refer to.
Oh, I put it in the wrong spot.
Yeah, you put it in the wrong spot.
Yeah.
So then the second sentence the second reference would be, within 60 days after the filing of the inventory or supplemental inventory. That's all we need to say there. The PR mails or delivers a notice of disallowance of the claim in whole or in part, then the claimant, and if any, the attorney, to the claimant. So there's that.
I think we're the only ones who are ever gonna understand what this means, but.
It's always fun to just hide those little nuggets in the statute.
So can we put parentheses in there?
Yeah.
Just trust us.
Well, let's see it again. If the petition, let's go back to D. If the petition for appointment states there's no assets and assets later come into possession or knowledge, a claim presented to the PR before the filing of the inventory or supplemental inventory for a first showing asset shall be considered as allowed as presented unless within 60 days after the filing of the inventory or supplemental. So that seems straightforward.
All right, this is the very.
You've got a claim, there's no assets. I'm not gonna do anything about this. Now I file an inventory that says, oops, I got assets. That obligates me to now respond to those claims within 60 days.
We'll put Lane's cell phone number in the.
Okay. You know what? This is a true story. I get calls from lawyers asking me about a bill, from 1999, and what did this mean? And I don't even remember the bill.
Our name is not it.
Huh?
You were the chief sponsor.
Exactly. I may have been the chief sponsor. I don't know.
That's what the legislative history.
But they think they're gonna get, that kind of extra nugget behind the legislative. Look, I remember, I know what you read me. I have no idea. I don't know why I said that.
Brooks made
Hey,
me
Lane.
Yeah, John.
Made me say it.
You read inventory or supplemental inventory when the, draft only says inventory?
Because we're gonna change that.
Yeah, we think.
It makes it consistent with everywhere else that occurs. And then the next time it says that, it'll just say inventory or supplemental inventory in that same subsection or subparagraph or paragraph.
But I'm thinking of the sixth line presented before the filing of the inventory, and that should be or supplemental inventory.
That's right, first showing assets.
Yeah, good.
Okay, then let's go on to section 9. And I will leave it at 11:15. I've got an appointment in Dallas at 11:45 that I could not get out of, but let's keep going. If the petition, no asset, and no assets have come in, you can move to close the estate no earlier than 4 months after the latest date of delivery or mailing of information. Okay, so that's just a motion to close the estate. Motion must state that no assets have come into possession. PR shall set a time for filing objections, not less than 20 days. That's consistent with our final inventory statute. PR shall mail a copy of the motion to close. If the court grants the motion, court will enter a general judgment closing the estate and discharging the PR, operates as release, and court may, and so they would just incorporate that. Okay. Are we okay with that? That's our motion to close the estate where no assets have come in.
I have two questions.
Yep.
On subsection 2 of that section 9, do we want to add, and the purpose for the probate has been accomplished, make them say that, or do we just let them get by?
Well, we did say that in the petition, you have to state the purpose.
Right.
Sure, and the purpose, just like wrongful death.
I'm not, I guess we say that, but sometimes you find out that there's no assets. The purpose was to probate the estate and you found no assets. Is that the purpose? Because we're talking about.
Well, this is under the specific circumstances where you filed a no asset petition.
Or you filed an amended
This is
petition,
filed for a
and you-
specific purpose.
an amended petition would still have to say, and it may just say, I made a mistake.
Or we didn't know.
Yeah, I think it's fine. It's innocuous.
And then the next question I had is at the top of page 8, in the normal statute, it's the action that can be brought after the entry of the judgment to the personal representative and any surety. And so I'm assuming the court has waived the bond.
Yeah.
Is it possible that they could require a bond?
No, because if there's no assets, it's an absolute waiver of the bond requirement.
Okay. But there are courts that sometimes, regardless of the logic of that.
We want to give the surety the discharge. There's no harm to this.
Doesn't it but doesn't it inject some ambiguity, some unhelpful ambiguity?
And then I gotta put it back in everywhere else too, because we took it out everywhere.
Yeah, let's take it out.
It creates ambiguity, but then our legislative history needs to
Yep.
clearly state
Well,
Oh my gosh.
that we don't have that in there.
because they're not required to file a bond under,
And we don't anticipate the court imposing its own
yeah.
rules.
Well, you can use that if a judge does do that, then I guess.
Yeah, that's, yeah, you'd fight that battle up front.
Discharge the surety. I'm quite positive of it.
Yeah, I don't wanna say surety in here because it raises the question, why.
I put a note on the recording.
Okay, good. Okay,
With Lane's phone number.
yes, with my phone number. Call Rick.
Link.
I have a question.
Matt.
I lost
Right.
my place. Here we go. So, section 9 is if you opened a no asset estate and no assets came in your possession.
That's right.
Here's how you close it.
Yes,
If you opened an estate thinking there were assets and then discovered there were not, Heather suggests filing an amended petition to state that there's none, which I guess I just want to talk this through.
yeah,
You could do if you want to avoid some of the obligations. Say you find out quickly and you want to avoid publication, maybe even if you find out within 30 days, you can
right.
avoid notice and stuff like that. That sounds reasonable to me. And if you find out after that point, so you've already done everything that you'd be required to do as a regular PR because you thought there was assets.
Right.
You then discover, so maybe the asset was, you had a piece of land where there was a disputed interest, and you finally get that resolved, and the estate has no interest. Then at that point, you just file a final account saying there are no assets available to distribute.
Yeah.
Motion, and it's just as easy.
Well,
to file, no, because the motion under this section has to be that you actually have a petition, and you're saying they don't go
Right.
back in and amend because you've already done anything in the way
Yeah,
of money.
yeah,
And so I think you're right, that the
Yeah.
simplest
Or
way to do it is
statement
a final account.
Yeah.
Because otherwise you have to go back and do notice to heirs and devotees. When you file an amended petition, you have to re-notice your heirs and devotees. So if they do everything they're supposed to do anyway, yeah, you can just file a final account.
yeah, no assets.
that makes sense
Yeah.
to me, because I don't want to, we shouldn't be creating
Right.
new hurdles.
Right, yeah, no, I think,
And Sandy, you should probably mark that too.
yeah,
Sorry.
yeah,
No, I got it.
that's a good point.
Now, is that a circumstance where is there a circumstance where you could have already gotten your bond, then you discover there's no
Yes,
assets?
yes.
And now you're closing it, but you do have a bond and a
Yes,
surety.
that's,
Yeah, and you go to, when you
So
do
do
the
we
final
need surety
account.
back in?
no, because that's not a section 9 case. Because you thought you had
Well, this
assets.
one, yeah, right. This one, you're not gonna go through.
No, you're gonna-
amending
you're gonna-
it. Are there reasons why you would amend it, and then, but you still have a bond anyway, you already did it.
In that case, I would,
But then you're not.
that's right, yeah, under the 115,
Yeah.
yeah. I would just ask the courts to cancel the bond. Yeah.
I have that bulleted for Susan when she goes next.
Lawyers can work this out.
Yeah, I just think that we rely on the UTC, so much, that desk book gets pulled out a lot, and I would like to be able to have lawyers have the same resource for this.
Yeah, well, that's what our reports are intended for. Okay, so let's go on to section 10. Personal representative, this is, within 30 days, if that's, again, your new subsection B is not related to this, that's just
No, this
just
is-
cleaning up the statute.
No, it is related, because, this was taking out, it was because we wanted, we didn't want the person to resign and then get out of the thing, so, right, below, you couldn't file the statement if the personal representative was removed, that's what we were trying.
Right, but I'm saying this isn't related to the no asset estate.
Yes, the intent, yeah, this was taking resignation out of C and making it its own thing, so below you'll see that there's something that happens with and B, but not with C.
Okay, then let's go on.
Yeah.
Oh, I got you, I see what you mean, yeah, on page 9, sure. Unless otherwise provided by order or rule of the court, the PR may file a statement under this subsection in lieu of 1A or B. Okay, that's right, there you go, that's right.
You can only do it if you have the annual or the resignation.
Yeah. Right,
Or
gotcha.
removal or-
That's right, you don't get out of it under removal, because you've been bad for some reason. Unless, okay, the PR may file a statement under this subsection.
So I kind of had a shudder when it said rule.
Yeah, take that.
Yeah, where did that language come from?
Where did that?
Yeah, I would, yeah, because that's incorporating, that's elevating rules to statutory
Oh,
status.
it's probably, maybe it was because, did this come out of the UCCR in the first place, this thing? That's probably.
This is the one, let's work this, we gotta get the judges back in here to have the conversation about this one. Because this is the statement in lieu of an annual accounting, right?
Right.
Uh,
I think Judge Cobb has some reservations.
right, but let's smith it.
Looking at
Lane, I gotta say, I really oppose the exception for an order of rule of the court.
Yeah, we're gonna take that out.
So the whole
Oh, just
thing,
the
Oh.
order?
unless otherwise provided by order or rule of the court, take that out. And it just says, the personal representative may file a statement under this subsection, because it's entirely permissible in 116, right? There's no, prior court approval for that.
Right, well, there's my statement in the final account, you just get a file.
Yeah,
Of course, you're gonna say
116.083,
no, you
a
can't do that.
personal representative, it's not, the court doesn't have the ability to decline or,
Right.
the right to file a verified statement.
Yeah, what we can do, we're gonna do,
I think
this is not a no asset case. This is, you've got assets, so, I mean, are there occasions where the court would say, I don't know.
So A says unless the court orders otherwise annually. So if you're gonna order an interim accounting because you think there's been funny business going on.
Right.
So 116.083A says unless the court orders otherwise, every 60 days after the anniversary of
Right.
the appointment.
Right.
And then 30 days after removal. So what does we're leaving that language in. So what does 3A have to
Well,
add? Because I think it's just allowing for the statement in lieu, right?
well, one is the requirement of the accounting. So that, unless the court orders otherwise in 1A, does not carry over to 3.
Unless the court, you have to make an account every 60 days, and then you can file a statement in lieu of 1A or B.
Right.
The distributee's consent in writing, so, so
I was just saying that unless otherwise provided by order, doesn't carry over from 1A to 3.
that's right.
Yeah.
So take that out entirely, because when you look at 116.083 paren 3, it just says when the estate is ready for final settlement and distribution.
Yeah,
There's no.
But this is an annual accounting.
Yeah, and I think we put that in there.
I do too.
For the court, to give them the ability to override this, but I would rather just be provided by order.
Yes, not by rule.
Yeah,
Right,
that-
right, because rule then can trump the statute, and that's crazy.
Yeah, no, that's wrong.
Unless, I think so, and I'm trying to leave something in here for the courts.
Why?
What about a standing order?
Entered in this case specifically. Jeez.
Oh,
Okay, keep going. This is great stuff. We're almost done here, and then, we've got the wrongful death done. We're gonna finish this before we get done today, before you get done. Next time,
can we talk about what you want, or did you want to talk about what you want to do with these drafts, or are we talking about it?
oh, okay, let's go offline.
Yeah,
Okay. Oh, and I wanted to get back, Ricky, you had the question about the rule authority.
Yeah.
So cover that before you leave today too. Okay, I want to make sure you get to bring that up.
Okay.
All right, so we'll see you all. Happy Thanksgiving, everybody.
Can you put in there a note that says, the goal of subsection 3 is to eliminate the expense of an interim accounting if all people, consent in writing? That's the goal, right? It was to eliminate the expense of an interim accounting.
Got it. And what I'm doing just on these notes is Susan's writing the report, so I have a full recording of the meeting, I'm making notes, and I'm just gonna go through it with her when she's a little bit of time in a couple weeks. But thank you. If there's any other notes you want in this whole process, just let me know.
That's actually it, we can talk about what is in this statement. That, I'm thinking that came from the UTCR, am I right about that? 'Cause that's where that order or rule part came from, I think.
So what must include?
I would add to, big letter C, a copy of last bank or financial statement received before the accounting for any account owned by the estate, because there could be more than one.
Oh,
Do we want to make any provision there for redacting account numbers?
No. That's already in the statute. You can eliminate it under the, well, I guess you have to do the UCCR privacy affidavit. Okay, let's include in chapter 111, yeah, because then it would be.
Anytime bank statements or whatever are required, you're allowed to redact at least.
Any financial
three of it.
institution,
we have one like that for social security numbers somewhere.
So that's the UCCR for confidential information.
You only have to do that, you only have to get the court's permission through 2.100 if it's required by statute. Because you can redact all day long if you want, just file it with the court, because we're not asking that you give the account numbers, the full account number here.
Well, but we're asking for the statement, and I could at least see the argument being made that a redacted statement is not the statement.
I don't know that, I haven't heard of a single court having a problem with
we'll
that.
take care of it in 111, just to be clear, because in 111, there's a lot of cleanup that we're doing. I mean, like, well, what is practice versus what is, what the statute says, they don't match.
So I have another question, if I would leave it about 5 minutes. In this statement under D, it says the amount of allowed and unpaid claims. Do we need to have any reference to any disputed claims that haven't been resolved or anything like that?
Well, you wouldn't be able to do it.
No, you can, because it's just a distributee that can plan. And it seems like there could be people where there's a pending litigation over a claim, and
I
The
think
estate's not ready.
said distributee.
right,
Not
we did.
creditors.
But I'm just saying, the court should know, okay, here are all the allowed and unpaid claims, we can't leave out a disputed claim or some pending litigation.
That would be an unpaid claim, because that's.
Well, and that's, I mean, the way it's written, unpaid and, allowed and unpaid, is that a conjunctive or separate?
Yeah, that's a good point. But I would read that as, they're both allowed and unpaid.
Yes.
But, yeah, that's a good point.
And
But it
maybe
can
we
also
should
be
have,
the other way.
they also have to describe any pending litigation. Because that could be something that is happening that, about. And, normally it's gonna be none.
Wouldn't that be, if there's litigation pending, it would be 3 big letter E, a statement describing why the estate is not ready for final settlement and distribution. You just include it there.
Yeah. But it could be that you have property. So, that's true. That is a reason why the litigation.
And then under little letter C, if you're trying to screw a creditor, you're still stuck because you have to give them notice, and then the creditor entitled to the notice can require the accounting. So there are protections for creditors.
Well, maybe what we do is we just change G to say the amount of unpaid claims and the identity. I mean, we should probably have to identify the creditor and the amount of the claim. Because I know those are people the court knows have to receive notice.
So D, big letter D would say, outstanding creditors, amounts allowed, unpaid claims, and disputed claims.
So we want the list of these creditors?
That makes sense,
Is a
because
list.
then the court can see who's entitled to notice on the proof of service.
So a list of unpaid creditors?
Yes, and the amounts of the unpaid claims.
And the amount,
Did we write it this way though, so if a person's claim was disallowed, we didn't have to re-notice them?
Right, well, we got one, that's right. Well, I don't know.
Okay, so, Marissa, I think that the goal is the amount of allowed and unpaid claims. Because disallowed, I think your language is right, because if it's disallowed, you don't want to have to re-notice.
I kind of remember that.
But it's disputed
Yeah.
and not resolved. I mean, if you just, if there's a disputed claim, you can't just.
So it could be the amount of allowed and unpaid claims and the amount of any disputed claim.
Okay. But the comment should make it clear that disallowed claim that has not been carried to the next level is not
Right.
a disputed claim.
You really think that and should be in there?
Anything
I'm
more?
just struggling with it a little bit.
The allowed and unpaid? Well, I noticed
Yeah, I
that,
already
that,
Okay.
I want to fix that.
Yeah.
Well, I think the thought at least there is that if the claim is allowed and the person's already been paid, why do they need notice?
No, I understand what it's supposed to do, it's just the way it's written, it could be perceived as, I have to list the allowed claims, all of them, and I have to list all of the unpaid claims.
Yeah.
Separate, as opposed.
Claims that are both allowed and unpaid.
Or what about unpaid creditors with allowed or disputed claims?
You could just say unpaid creditors, period.
No.
Regardless of the.
No, because.
Oh, that's right.
They're
They already
no
get
longer
notice.
disputed.
Then they don't get notice.
Okay, I like that.
That's right, sorry.
Okay.
Well,
Yeah, but I don't like that word creditor, you know why? Think about that. What if you send a notice to a creditor and they don't make a claim?
Claimant, what's the, I don't know. I don't think they're a creditor
Where
at
do
that
you
point.
know? Yeah, they are.
If they haven't-
Claims that are allowed or disputed, unpaid claims that are allowed or disputed?
if they haven't submitted a claim, don't you assume they're paid in full?
It's not an assumption that they're paid in full. It's an assumption that they are out of luck.
We don't define creditor, we define claim, liabilities of the decedent in 111.
Marissa, you know what we need?
Yeah,
She-
okay. And then the C, I think we talked about this before, about the notice to creditors. I think I came up with this, so somebody read it. And then that's it. I think the last section here is just, number two.
In C, don't we have the same issue? Are we taking the position that creditors who would be entitled to notice are only those with either allowed and unpaid or disputed and unpaid, but not disallowed and they haven't asserted their right to
That's what I think, otherwise, why would you, then the whole process of allowance and disallowance becomes.
Yeah, you could still be
Yeah.
having to serve notice on creditors whose claims were disallowed and they didn't
Mhm.
file to meet
Yeah.
their claim.
Put more words here to address that. I feel like that's probably, if you waived your rights for whatever you haven't done, then that's.
You're no
it for
longer a
you.
creditor. If you've waived it,
Okay, I'll make a note.
lost it.
Next meeting is scheduled for, November 29th. So it's the Thursday after next. It will very likely be in this room. I'll confirm that.
Right, so you want to do yours? That, the 29th, isn't that, the one I'm asking? It
Well-
looks like that's the big grand
Oh,
hoopla for the trees out there.
parking.
But I don't know what time the,
I think that, I believe the tree thing is gonna be after we meet. But I will, before I leave, they have a flyer up front, I will.
Heather, before you take off, since you were one of the objectors about the rule making provision in the statute, and I'm not gonna probably be here next meeting, because I'll be in Fort Carson, Colorado, saying goodbye to my son before he goes to Afghanistan. We did look up the statutes that give general power, rulemaking power to, DHS and OHA, and that's 413.042 and 409.050.
can you, sorry, I'm totally lost, can you give me a little context? What statute are we talking about?
We were talking, what came up was in, on the wrongful death statute on page 4, at the bottom, where it talks about notice to DHS.
That's, I don't know, I'm objecting to that, go ahead.
And one of the things that was included in there was paragraph E, any other information required by rule of the Department of the Authority. And you and Jennifer both piped up objecting to that because you questioned whether we had rulemaking authority. And Marissa went along with it because of the way the PIL statute was laid out for
I
enumeration.
don't think our objection was to whether you had rulemaking authority, I think our objection was how difficult it is when you have rulemaking authority for us to, and then you guys said, oh, you guys already should be able to find it. Sounds really great, it's a lot harder than you think it is when you don't deal with them every day. So, that's what our objection is. So, what statute, what's the draft say now?
Well, that's still in there right now. We're on LC 89, page 4, just above section 7.
Oh, any other information required by the department or the authority. Required by rule, the department or authority. And I think that's a more practical than,
It's on page 4, yes.
it's on page 4.
That's section 6, and B.
Yeah. And I mean, I understand what you're saying, it's just, I think that that's more of a practical, we need to make sure that, DHS, OHA has, the information available, that you guys know what numbers to call, to ask the questions, to get the information. It's more of a education and being available to answer questions kind of thing.
I've had a lot of calls from newer lawyers trying to jump through the hoops to figure out that EAU has the right to receive notice for, because it says something different than EAU, they don't necessarily know. There's an administrative rule that says, well, we have to give notice, you can give it to EAU. And so trying to walk lawyers through that sometimes is part of the difficulty. Our goal is where our common denominator. And so, if you guys have rules, it's helpful in public. lawyers now know that even though the rule says, send the notice to A, you really send it to EA. And that's the kind of difficulty, the practical difficulty.
Yeah, and part of that is getting the attorneys knowing that they need to always look at the rules as well as the statutes, and then getting on the notice of, rulemaking, with those rules, because then they can get automatic, if there is additional information required by the rule, then you're gonna get notice of that rule before it even becomes a rule. And then you have the opportunity to have input on it too.
So when you ask for, notice about rulemaking, you have to decide what you want notice about, right? Yeah, and so the difficulty is you don't have just the right area of the rules, you don't get notice.
Again, that's more of an education issue than something you
Well,
can't
you're saying
take away.
Yeah.
The agency has authority to promulgate the rules, and they have the authority to do this. And so it's incumbent upon, all of us in educating, especially newer lawyers, that maybe that needs to be in CLEs, is that there needs to be more, a whole thing on rulemaking, and not even just, obviously for probate, concentration, but, that might be part of something for the lawyer mentoring program.
We could publish that like in a PLF bulletin, I suppose. We could,
Taught that in school, that there exist administrative rules we need to pay attention to.
we could talk about the specific.
That's like all the back doors, that's what my point is. And so, yeah, putting it in the PLF, that's great.
I do try to get information out there, and of course, my ability to do that is a little more limited than it once was. But, and to be really blunt, my efforts to communicate with the Oregon trial lawyers is generally not very, productive. So, I don't know whether I can use them as an avenue to help spread the word on this too. But I'm sensitive to that, and I don't wanna hide things from people, but I also have a duty to make sure that I get the information I need to carry out the obligations that the federal government and legislature have mandated.
And I don't think we're asking for some easy ride, that's not what we're asking for. But I'm guessing that you have never had to try to get notice of proposed rules and try to register for that, have you?
Now that I'm in general counsel, I deal with that all the time. So yeah,
So
I'm really familiar with.
you ask for specific notice?
No, I
Just because
understand
of
the
your job?
process and what people do to get on, the notice and to get on the list. And so,
You think it's simple?
I don't think it's, I think if you say, I want these rules, and you know what the rules generally are here, the OAR, then that will get you, most agencies are pretty good about getting those notices out.
Could you not identify what chapter you're referring to?
In the rules?
No,
Well, those could be, no, you're not gonna put that in the statute, but.
Sorry.
There is every.
Effective notice and not told us.
The guidance.
Yeah.
You don't get more
Hey,
than this
here's
in
what's
any
wrong.
other statute. It
I'm
says,
sorry.
or any rules that the agency might promulgate.
Every
That's your
single
notice that
agency
you
has
have to
rules,
go
yeah.
research that agency's rules to find relevant provisions.
And so then you're relying on the index a lot of times, like when you're searching, you're relying on the index, because they're not always well cross-referenced. This aren't.
Yeah, but if we didn't
Neither
have
are
rules,
statutes.
Yeah.
you're basically asking for the rules to all be in the statute, and that's just
No, I'm
not
not
how it
asking for
operates.
rules to be in statute, but,
I realize, 'cause
Yeah.
I have the same frustration with the ordinance. We have, the OCPs, and we have the UTCRs, and we have SLRs.
And then in Multnomah County, you have the super secret rule.
Yeah, there's like multiple layers that you have to go through, and it's frustrating. And I think part of what we're trying to do is, particularly in cases where there's differences between the court's practices, we're trying to, if it's appropriate, put it into the statute so that it's going to be streamlined. But this is as much as you can kind of reasonably mandate for coordinating a statute with an agency rule.
Yeah, I didn't bring it up today, but I think you guys have if your goal is to get people to follow the rules, which I think that's the committee's goal, is to help people practice better and modernize, then you have to accept some responsibility for how difficult things are to find. I get it that you know that the SLRs are difficult, the UTCRs, the ORCTs, and the statutes, they're difficult too. But the difference between that and the rules is you don't always know what chapter to look in when you're searching. And so, yeah, and they're as bulky as the statute, but the difference is usually you can find things in the appropriate chapter in the statutes, and I wouldn't say that's always true with the admin rule.
So, practical question. I know I've submitted a couple of things to Medicaid and other places and got kicked back. You screwed this up. There's a rule that says you did it wrong. And I've always been able to say, okay, great, what rule? And I've never had a problem getting a response back at some point saying,
You're asking the wrong
this is what
person.
we've changed. And so, I mean, maybe I'm having a different practice experience than you are. But anytime I've been told that I did not provide the correct information to an agency, I'm also told this is where the information about what you're supposed to be providing me is at.
Well, I'm sensitive to what Heather's saying. I mean, some of the newbies and solo practitioners don't even know, even try, and I get that. But if we have this in here, this at least puts them on notice that maybe there is a rule out there and that maybe it does need to be found. It doesn't necessarily give them the answer, but at least it warns them that it's there.
And rule numbers, I mean, you can't put that stuff in statute because they change all the time, and it would make the ORSs triple in size just by referencing OAR or whatever. So, you know, I mean, the reality is that it's incumbent upon everyone to educate folks. And we've got the system that we've got. We can't change the OARs and the way they are. That's not what the purpose of this.
Yeah, so what, so you know, if you were, like, you didn't practice, say you didn't do Medicaid or things like that regularly, and you just see something that says, by rule of the department, which department?
The departments are the department.
The department means DHS and the authority means OHA.
Yeah.
The initial paragraph of that section says Department of Human Services and Oregon Health Authority.
So if you can count on that in the statute, we usually get that right.
The heading?
No, the first reference will be the whole agency or title, and then we'll start using department. And if there's two departments in the statute, we'll use, you know, Department of Human Services and Department of Revenue are both in there, and it's gonna say the full name every time.
Yeah, well, from my world, they're not the same, trust me, but anyway.
I know, but, you know, yeah. So we should say the department or of the authority.
It says that in mine.
Yeah,
It does.
He says department or authority.
Which, by the way, is all one, right?
No.
No, they're separate agencies.
We have to give separate notices?
By rule, they have that agreement that notice to one.
Is that in 461?
That's in 461, and it's also in, I want to say 943, or 410, I forget which. Because what happens is when OCAR promulgates a rule that affects both OHA and DHS, we promulgate the rule, we put it in our DHS rules, and then what happens is there's an all-encompassing rule that OHA incorporates by reference.
And OHA is 410?
OHA has 410, 943, and I forget which one it's in. But it's in one of those two. I don't have the number memorized.
You know, when I try to search for rules like this, I just search statute number, and, you know, some agencies are better than others at putting the right statute number as the what do you call that, the authorizing.
Yeah, mine, I try very hard to get that right, far more than many of my
So what's the
colleagues.
website that you use to?
The Secretary of State
Website? We use OAR, you search in OAR for an ORS?
Yes.
I don't know how to do that.
Secretary of State's website.
Well, I use Secretary of State's website all the time, but I don't know how to.
Doing there is an option
We'll
to
text search, and then you could filter by chapter.
Okay.
You might have to filter by chapter, and then the exact thing, you put in the statute number and search for that. Good way to do it.
So you can filter by chapter and then put the statute number.
Mm-hmm.
So that's the kind of stuff that needs to go out in CLE. Because we use that website. Kathy, have you ever been able to do that? How do you do that? Okay.
That's a good thing for the Oregon State Bar to.
Maybe I should teach CLE on how to search for rules.
Serious.
No, it's
Bad
not,
idea.
I think, I totally agree, I think that's, you know, when I was saying, the new lawyer mentoring program requirement, you know, is teach people those practical things to do.
So the
Absolutely.
lawyer mentoring program, they don't have enough mentors. Yes, you take them out to copy and they're not teaching them how to practice law, because it's too expensive to take. You have practice to take time to teach an associate. So in theory, that's great, but it's working all that way. The way the information is getting to those newer lawyers is CLE. Oh, that's great.
Well, and I used to post the noticing the EAU thing on the listservs on a regular basis.
But,
I mean,
something that is like, that you can access instead of like scrolling through your, doing a search in your listserv that you saved, if you saved them, is a newsletter.
I was
think that's a
hoping
really
that
good
people would print that out and stick it somewhere, but.
Maybe Marissa could.
What?
Write
Write an article for all.
I can tell you, I do the administrative rule review coordination.
So we could put your name forward, like, there for the elbow.
To write an article? Yeah, sure. I don't know what I would write about.
Probably after the
We can tell
session.
you.
Yeah.
We can tell you what, because I get those questions.
Yeah.
And so I'm done writing,
And that way you can put links in and things like that.
I like that,
Practical tools
yes.
and tips.
I think that's a great idea.
Sure.
Yay!
All right. So Rick, are you satisfied with the discussion?
Well, I'm okay. I mean, I was just trying to respond to Heather's concerns as best I could.
Yeah, thank you. All right, I guess unless anything else to discuss, we'll adjourn.
Is your son being deployed?
What?
Is your son being deployed?
I'm sorry?
Is your son being deployed?
Yes,
Oh, is that the first time or?
yes.
Oh, wow.
Going to Bagram, Afghanistan. Fortunately, he's a